Welcome to the NJ Criminal Podcast and part 2 in this series.
So let's just switch gears for just a couple minutes and talk about, offenses that are alleged to have been committed or have been committed by individuals who are either have received a green card and are in that 3 to 5 year period of time where they are trying to become United States citizens, right? Because that could have an effect on their ability to either keep their green card or proceed further, or individuals who want to get a green card. So the types of offenses that, for example, I have clients and maybe they come to me and they've been charged with a DWI. That's a very common scenario that I have with some of my clients here in South Jersey. They're not here legally. Perhaps they are married to a United States citizen, or they want to pursue legal citizenship, or maybe they aren't even looking to become a citizen, but they don't want to get deported, right? They're here, they're working. They know that they don't have any path to become a United States citizen, but they come to me and they have been charged with either in New Jersey, we would call it an indictable level offense. We don't call them felonies in New Jersey, or even a DUI refusal, like you said a couple minutes ago, and are concerned about the impact of a conviction, which could get them deported, right? Whether they have the ability to get a green card or not. So, we have when people are putting through pleas, there's a whole colloquy about whether or not individuals are United States citizens, whether or not they want to have the opportunity to talk to an immigration attorney who's basically probably going to tell them, hey, you could get deported, right? And all of that. So that's where you get into the crimmigration, right? Crimmigration, right? This term, I get solicitations all the time for different CLEs. Talk to me about that and things that criminal defense attorneys need to be aware of, when a criminal defense attorney needs to reach out to an immigration attorney, and what, if anything, that immigration attorney like you could do to help someone in that situation, really, other than tell them, hey, if you plead or you get convicted, you could get deported.
No, we do a lot more than that.
Right.
And,
so tell me.
Well, the reason we're talking is because I reached out to you because I do have a podcast of my own called Immigration Review. And every week I analyze all the published circuit decisions, including out of the Third Circuit. And I do an explanation on what they're talking about, the immigration concepts they're talking about. And a lot of those decisions involve crimmigration. So, every week on the podcast is a primer on criminal immigration issues, so long as the circuits discuss it, or other immigration issues. So, I try to turn it into a teaching thing. People are getting CLE credit for the podcast as well.
That's great. It's good to know. I always need CLE credits, and I always want to listen to the experts like you. So just as a reminder, all of our listeners, check out Kevin's podcast, Immigration Review.
I bring it up because, there are so many different aspects to this. So to touch on DUI, DWI first, it's the most common deportable offense, but it's not a deportable offense. And, that's
right.
Clearly I'm trying to target, right. But your clients, for example, who are here without authorization, they're deportable right now.
Anyway,
you don't need the DUI,
right?
And so the number one way that non-citizens come into contact with law enforcement is through DUI, DWI. Someone who's been here 20 years, they don't have a right to be here. They've been under the radar. They get that DUI. Some jurisdictions, they can't forget about you. This is what sanctuary city is. This is the main thing this whole sanctuary city dispute is about. Florida, DeSantis passed a bill that says cities can't be sanctuary cities. And that means that when a non-citizen is arrested, they got to notify ICE. And if ICE puts in a request to detain that person, even if they pose bail, you got to keep them for a certain amount of time, and then ICE comes and they get transferred into ICE custody, and removal proceedings start, and it all gets triggered.
Yeah, there's been a lot of discussion in New Jersey about whether or not law enforcement, and then there was an Attorney General directive or guideline that came out a couple years ago about whether or not law enforcement to have the requirement to reach out to ICE. I mean, you used to hear stories about ICE showing up in municipal courts, right?
Yeah.
You don't see or hear about that anymore, but I guess there's always that risk.
Well, it's happening up until the current administration. There was a judge in Massachusetts who got criminally charged, I believe. I can't remember if she got convicted for not necessarily complying with the courthouse arrest, trying to facilitate but we digress. If you have a green card, a simple DUI or DWI is not going to generally get you deported. It's not a deportable offense. Generally, a simple DUI, DWI, but nor will it prevent you from getting a green card. Generally, if it's a simple DUI, DWI. But again, if you don't have a right to be in this country, getting brought to the attention of law enforcement is sometimes worse than all of that. Now, if you have a DUI, an aggravated DUI or something like that, then we're getting into other territory, and that gets into the most common and amorphous criminal type term. It's a crime involving moral turpitude. Sounds like something straight out of the early 20th century,
Right.
and it is.
It sounds very broad.
It is, and it keeps getting challenged as constitutional. The Supreme Court last took it up in the 1950s. It used to involve crime involving moral turpitude. It is broad. I think it's applicable, correct me if I'm wrong, in criminal. Sometimes in the criminal context, it's the same concept. In immigration law, and this is where the categorical approach comes in. And if you do federal criminal work, if any of your listeners do, this is the same concept as the Armed Career Criminal Act analysis, applicable in federal court to enhance a sentence under certain circumstances. So if you're in federal court, if you're coming in and you've got, I believe, 2 or 3 prior offenses, if those 2 or 3 prior offenses match certain federal definitions, your 10-year robbery could get enhanced to life, for example, if you have, 2 or 3 violent felonies. And I'm not an ACCA attorney, but that's the concept. And so it's this matching. That's what crimmigration really is. It's the matching of a state conviction, the elements of it, with the definition of a removable offense. Okay. And so let's talk about crimes involving moral turpitude. Under the right circumstances, a crime involving moral turpitude or a CIMT can prevent you from getting a green card, or under the right circumstances, it could make you lose your green card.
I'm just thinking, arguably all crimes are.
But there's a federal definition. So right. That's what all this case law I talk about is. In the CIMT context, what is a CIMT? Well, there's case law. Generally, a CIMT is a crime that is base, vile, or against the general accepted norms of society, or everything that involves fraud or deceit. So it's like this grandiose thing, or the fraud crimes.
Right.
And
what isn't? What crime
isn't? Well,
is
no,
it?
there's a lot that isn't, and it depends on the circuits. In the Ninth Circuit, you're going to have better CIMT case law than in the Fifth. And it's crazy. But, CIMTs used to be sodomy offenses. Obviously, you can't do that anymore. So the Ninth Circuit came out with a decision that I talked about on the podcast just 2 weeks ago, Walcott v. Garland, where the Ninth Circuit was saying with marijuana, as society's values on marijuana changes, so do Arizona marijuana trafficking. That might not be a CIMT anymore. Okay. So it is based on that, and
have some of these cases going up to the Supreme Court?
So, again, the Supreme Court hasn't touched CIMTs since the 1950s.
Oh, they haven't. Okay.
They should again. But so CIMTs get really confusing. So let's talk about maybe an easier one for the concept. There are about 30 what are called aggravated felonies at immigration law. And aggravated felonies gets really complicated, but they are something that can make you lose your green card. It's not necessarily applicable if you don't have one yet, but if you do have a green card, or if you are otherwise here lawfully, you can be deported if you've been convicted of an aggravated felony. There are 30 of them. They're defined by the statute. One of them is a crime of violence, an aggravated felony crime of violence. That's the immigration
So somebody that
statute.
has a green card on their path to become a United States citizen gets convicted of one of these 30 defined.
Well, they get convicted of New Jersey assault with a deadly weapon. And then the inquiry is, does that meet the definition of an aggravated felony crime of violence?
Got it.
How do you make that determination? Well, the aggravated crime of violence definition is in turn defined by 8 USC section 16A, which is a federal criminal violent force statute. And so does the New Jersey assault with a deadly weapon necessarily, for example, require in all circumstances the use of violent force? What is violent force? The Supreme Court said it a couple of years ago in the Castleman decision, and they've said it a lot of times. It's always evolving. So these definitions of federal removability provisions are constantly being redefined by case law.
And is it handled on a case-by-case basis, depending upon the individual circumstances?
It depends. It depends on the removability.
Sounds like
provisions.
A lawyer's answer.
Right. Well, let's talk. I'll give you an example. Another aggravated felony is the federal definition of an aggravated felony, a different one. Any crime that involves fraud or deceit with a loss to the victim of over $10,000. That's the definition of an aggravated felony. So there's two elements essentially. Does the crime involve fraud or deceit? Did it involve a loss of over $10,000? The fraud or deceit analysis requires, we don't care what actually happened for the fraud or deceit analysis. This is the categorical approach. All that matters is what the statute requires. So, I don't know, New Jersey extortion. If it always involves fraud or deceit under the New Jersey statute, then you meet the first element. But if you have some weird case from the New Jersey Supreme Court, which says actually sometimes it can be done by reckless extortion, then actually it doesn't always involve fraud or deceit, because immigration has to defer to the highest court in the state. So in that case, the New Jersey Supreme Court on that crime, New Jersey extortion, I just made it up. But let's assume that you've got a New Jersey crime that case law and the statutes shows it always involves fraud or deceit. Well, then the question is in this specific case, did it involve a loss to the victim of over $10,000? So that's how the two things can come into play.
So you really need to be an expert, or at least have the ability to research separate state laws.
Absolutely. That's the best criminal immigration attorneys. You have to be able to look at the state and federal case law, because you have to define the state offense and you have to define the federal deportation offense.
Right. If somebody's putting a plea through, does it come down sometimes to what they place on the record to when they provide a factual basis? Is that sometimes important?
Yes, but not nearly as important as the actual statute of conviction. Okay. Immigration judges are not supposed to go behind the record of conviction, and there are only certain documents from criminal court that you can even rely upon in state court, for example.
Well, so this is right. So this would be why, and I'm sorry to interrupt you, but this would be why a criminal defense attorney should consult with an immigration attorney like you before negotiating which count or counts of an indictment. So to, for example, their client is going to plead to, because it could have long-lasting impact.
100%. And after, I want to say, the 2008 decision, Padilla v. Kentucky out of the Supreme Court, it's ineffective assistance of counsel per se for criminal counsel to get it wrong or to not advise. I mean,
so repeat that again. That's something everybody needs to remember.
Padilla's not retroactive. I wish it was. I want to say it's 2008, but certainly today. If the non-citizen isn't given certain advisals in state court, or if the criminal attorney gave affirmative misadvice,
like, nah, this isn't going to hurt you.
Yeah. It's per se ineffective assistance of counsel. It's grounds to get that vacated, and a good immigration attorney is going to be all over that when they're placed in removal proceedings to try and get the conviction vacated, because if the conviction is vacated and they have a green card, they're no longer deportable.
Right. Well, our plea forms in New Jersey were modified when Padilla came out to make sure that there was a colloquy done with the client or the defendant if they were not a
But
United States citizen.
affirmative misadvice might be an exception to that rule. And how do you prove that? But
Right. Here's an area I wanted to ask you about. We have a program in New Jersey called pretrial intervention, PTI, and they're every state, I would imagine. I know Pennsylvania calls it ARD, and so every state has these programs for first-time offenders
yeah,
that may or may not require a plea. It's a probationary type of program that if a person successfully completes it, at least in New Jersey, you're admitted into PTI. You successfully complete PTI. The case gets dismissed, lots of times without ever having a plea. And the general understanding among many criminal defense attorneys is that you're going to be okay if you have a client that is not a United States citizen, is not here legally. No guarantees, but not likely to result in deportation. Thoughts on that?
Oh, yes. So first of all, again, if they're here unlawfully and the ICE is being aggressive, it doesn't matter what conviction. So, you're already been brought to the attention of law enforcement. So now you're hoping the prosecutor doesn't tell ICE. But these are the most difficult and stressful types of cases that come to us. And I do specialize in stuff like that.
Because as a defense attorney, PTI is sometimes a home run.
The stakes are right. The stakes are so high if you get it wrong. And unfortunately, it depends. The definition of a conviction under immigration law, again, the 1997 change, is different than the state conviction and is owed no deference. And it is more expansive because the Congress was trying to get around states doing things that could help non-citizens through pretrial intervention. So if they're, and this is, sorry, the dog is barking next door again. This is again dumbing it down and not legal advice, and it's much more complicated. No. But if there has been an admission of guilt or an adjudication of guilt and some form of punishment, even if they then go into a pretrial thing and then they don't have a conviction and all that stuff, you probably have an immigration conviction.
Okay, that's news to me.
Trouble.
That's good to know. That's very good to know.
But it depends on the state. It requires a deep dive into what is an immigration conviction and what does that program in that state require. But, off the top of my head, there's an old Board of Immigration Appeals decision, which is essentially the Supreme Court of Immigration Judges. Their decisions are also binding. There's an old BIA decision from the 90s about New York's, I want to say, Youth Offender Act. Program, and that was deemed, at least then, not to be a conviction, but it's very specific based on the program.
Well, let's talk about juveniles. I handle a lot of juvenile cases. Are the rules different for a juvenile who's facing an adjudication as a juvenile? Or does it, again, depend on the crime, the individual's status, all of that?
Yeah, no, let's say you've got a 15-year-old with a green card. Can a conviction make them removable? I believe so. But if they get into a special program, then it depends on the program. And, there are other protections, of course, which ironically, you doing your job as a criminal attorney for that 15-year-old is going to make my life more difficult if you get the wrong conviction, because then I can't, say his due process rights were violated by bad counsel who weren't protecting the minor.
Right. Well, this is why I think criminal defense attorneys need to have immigration attorneys involved sooner rather than later. But there's not always a clear answer. I mean, and sometimes a resolution with a lesser offense is better than the risk that you may face if you go to trial and get convicted. It's two-edged sword.
Absolutely not to, promote me, but that is exactly what we immigration attorneys absolutely believe that. And so many times we see these convictions, like if only they had reached out to us beforehand. But it's also a two-way street. And I'm going to try not to get into the weeds here, but with this whole categorical approach, there is also something called the realistic probability test. It comes from the Supreme Court. It's this whole, matching the state offense to the federal offense. And it comes up a lot with drugs. If the state criminalizes possession, let's say, of more drugs than does the Federal Controlled Substance Act, then a lot more analysis is required and your client might not be removable. And so to say that in another way, let's say New Jersey criminalizes the possession of khat, which is it's like a Middle Eastern chewing stimulant. This is a real example too.
Mm-hmm.
Let's say Jersey criminalizes possession of khat and the federal government doesn't, because the feds are always behind, because states are always criminalizing more drugs than the feds. Your client might not be removable even if they were possessing heroin. And that's what crimmigration is all about. It doesn't always matter what they were doing. It matters what the statute allows. But some circuits understandably don't like this framework, and the feds have caught up. And so there are arguments, for example, that have been made that a state like New Jersey criminalizes more drugs because while the feds only criminalize, let's say, possession of cocaine, New Jersey criminalizes possession of cocaine isotopes, which I don't even know what that means. I think that's something to do with crack, whatever.
Right.
And the circuits will say, okay, fine, you got us. You're right. Technically, that's more drugs. But if you can't show if you can't show us a Jersey case where they're actually prosecuting that, we're going to look the other way. We don't care.
Okay.
And so there is a huge need in immigration for state court defense attorneys to provide their unique not even convictions, their unique prosecutions, and say, look at this case, because this isotope thing is actually something from the Fifth Circuit that I talked about on the podcast last year. It's a real case. If a Texas attorney at the next one comes and say, look, the Houston prosecutor was prosecuting isotopes and they got a conviction, then that whole Fifth Circuit decision is wrong. They do prosecute it in Texas, and that means that there is not a match and the whole crimmigration analysis. So the need is both ways for these unique cases, because immigration attorneys don't know what's not getting published on Westlaw.
I see. And so is this why you really spend a lot of time really thoroughly analyzing cases that come out around the country in your podcast? Because it's that important to be up to speed on all of the different decisions and all of the different circuits all around the country.
Absolutely. And all the different arguments, the isotope argument, that's I get a drug case that comes through my door. If the circuit doesn't preclude it, which it doesn't in the Ninth, I don't believe. I'm making that. And it helps me with unique arguments, and it helps to know what's going on to try and extend that favorable Third Circuit decision into the Fifth, into the Ninth, into the First.
So you've given us a broad overview of Immigration 101. We've kind of started getting into the topic of crimmigration. And, I could have you here all night on this Friday night talking to you. And I would love to have you come back. And I want to ask you, just give us some highlights. What are some hot topics? What are some, even just from the things that we've really basically given some broad brushstrokes tonight doing this overview? Well, what are things that you want to come back and talk about? What are some things that we need to keep our eyes on? What are things that me and my listeners need to kind of do a little deep dive in? And what's the future hold?
Yeah. Well, so first, before I do that, I want to just commend you, because as I've gotten excited and been talking about this, my voice starts to rise and I'm starting to yell. And I can only notice that you have remained, not only have you remained calm, but you've actually even calmed down even more. It's a great podcasting voice and a great podcasting.
Well, that's fantastic. Thank you very
demeanor,
much.
So.
That's funny.
Hot topics. Well, first of all, you have a criminal listenership, so always the updates, especially in the Third, because you're Jersey, but in all circuits, what is happening with the definition of these removability offenses? And sometimes it's as easy as New Jersey, criminal thing 1001 is an aggravated felony. I mean, sometimes it's that direct. And so no analysis needed. The Third Circuit said in May of 2021 that this exact statute is an aggravated felony. But sometimes it's about the analysis. And if you're really getting into the analysis, you need to be contacting someone like me or an immigration attorney who knows how to do that analysis. It just can't be done by even the most brilliant criminal attorney, because just like I can't go in and really defend somebody in criminal court.
Right.
An expertise is involved.
Right.
There aren't any criminal issues at the Supreme Court this term, but the big issue, there are a couple bigger issues to look out for right now. One is, what are we going to do with the Remain in Mexico policy at the border? I mean, the Fifth Circuit has ordered the Biden administration to restart it. Many people believe that it is an inhumane program that forces asylum seekers to stay in a country that many people seek asylum from, Mexico, in dangerous border towns, of which it is common knowledge that international gang cartels, they own every inch of U.S.-Mexico border. So these people are by definition in dangerous circumstances. What are we going to do with the Remain in Mexico policy? A lot of that will probably be up to the Supreme Court, because the Fifth Circuit has ruled how it has. Another issue that is always here that we didn't even touch on, but that's also near and dear to my heart, is detention of non-citizens in this country. I mean,
well, why don't you have you come back? Will you come back and talk about that? Because we could have a whole nother episode about that. I'd love
I will, but the Supreme Court is going to take it has taken a detention case this term. What do we do with that? And then what is the future of the DACA people and people like them? These are all issues that are percolating around here. So
how can we get a hold of you? First of all, where can we listen to your podcast, Immigration Review?
Thank you. Everywhere. It's on the Kurzban, Tetzeli, and Pratt website, where I'm a partner.
All right, tell me the website. Tell me the...
you just type in Kurzban, Tetzeli, and Pratt into Google or KKTP, but also it's on all podcast platforms, Apple Podcasts, Spotify, anything that you can find Immigration Review there. We also post it on the Kurzban website, and you can see what we do there. My email address is kgregg@kktplaw.com. It's kgregg@kktplaw.com.
Okay. Your phone number?
Phone number is 305-444-0060.
Well, fantastic. Great. Well, I can't thank you enough for joining us and giving us all of your expertise. It's unbelievable to me, the amount of information, the detail, just there's so much there. And, as with everything in the law, but I think specifically with immigration law, it's never simple. That's for sure. And this is why we need folks like you to explain it to us. And I appreciate you taking the time to do it in such an understandable way for our listeners.
Thank you, Meg. I appreciate it. I'd love to come back on.
Oh, I'll have you back. Definitely.
I'm going to get back to doing there were 8 cases published this week. And so I'm going to get back to recording my own podcast.
Oh, wow. That's fantastic. Well, I will definitely keep my ear out. How do you keep up with them all? I mean, that's a full-time job in and of itself.
No, I don't. Yeah. Weekends and late nights.
But you have to, I guess, based on everything you've said, you have to.
Well, no one else except my boss, Ira Kurzban, is reading every decision. And, the viewers can't see it behind me, that green book. He has been writing the treatise of immigration law for 30 years, maybe 34 years. And so he reads every decision, but no one else does it. And honestly, the idea for the podcast was my wife's, so I can't take credit, but it's a need that was there because they're all coming out. You can't do it. Some of the circuits email you their decisions. Some have an RSS feed. Other circuits, I just look at their website every day at a certain time. I now know, for example, that the Ninth Circuit publishes every day at 1 p.m. Eastern Standard Time. That has knowledge in my brain, and I can't push it out. But
that's great. Well, and it's a way for you to, I would imagine, like with anything, kind of, not that you need forcing, but force yourself to kind of keep current and stay current. Yeah. And as with anything, if you let yourself fall behind, next thing you know, it's 50 decisions later, and you're trying to play catch up. So you're doing a great service. Not just to other immigration attorneys, but to other attorneys all around the country.
No, thanks, Meg. My outline right now is about 950 pages, single space, since May 2020, and I think I'm over 1,100 cases since May 2020. So
you should publish that.
There we go.
You should publish it.
We'll see what the future holds.
All right. Well, listen, I'll stay in touch with you, and we'll have you back on very shortly. I'd love to continue this and maybe even have just a little series here on immigration law. And once again, to our listeners, Kevin Gregg, Immigration Review Podcast. Kevin, thank you so much for joining us. And I know that all of our listeners ought to be familiar with you and your firm, Kurzban, Tetzelli, and Pratt.
Thank you so much, Meg. It was a pleasure.
Thanks again for tuning in. And don't forget to subscribe anywhere you listen.